Good morning, Carla Hartley here. It is July 24th, and I'm continuing the series about how do you figure out how much money you can get out of the community property real estate or a separate property parcel to which the community contributed. We're talking about improvements. How do improvements impact the value of the house and what you're going to get out of the house? A lot of people think, well, I sunk my separate property inheritance into the community residence and we put a new roof on, it was $20,000, I should get that $20,000 back. The problem with that is a roof is generally not an improvement, it's maintenance, and therefore not subject to, it doesn't increase the equity in the house, it simply maintains the house. The rule for improvements, if you're looking at getting any kind of buyback or any kind of interest out of the separate property you contribute to the community property estate for the improvement, or for the community estate to recover from the other's separate property for an improvement, it's got to be an improvement first of all. It's got to increase the equity or the value of the house on the market. Not just increase your quality of life. It's got to be called an improvement. Painting is not an improvement. Replacing a water heater is not an improvement. Now, there's some argument that replacing, for instance, the old kind of 50-gallon water heaters with a tankless water heater might be an improvement, but you still have to have a water heater. So I'm not sure that you're going to prevail on that particular argument. And keep in mind, you want to be talking not about a $500 hot water heater, you want to be talking about something that's going to make the attorney's fees and costs worthwhile when we're discussing the improvements and your reimbursement for the improvements. So, the general rules. I'm going to give you two of the general rules, and there are exceptions all the way across the board. Again, these little 3 to 5 minute videos are to give you an introduction and an idea about what you might be entitled to. They are not the final answer. Separate property contributed to the community property estate. If there is no writing, okay, that waives the separatist interest in the money contributed to the community for improvement of a real property asset, then the separatist is probably going to be entitled to some sort of reimbursement for that separate property contribution. It's going to depend on how much that separate property contribution improved the value of the house. So, for instance, say that you simply redid a bedroom and replaced drywall and put some nice stuff in the bedroom. That's not going to really increase the value of a house as much as putting work into the kitchen, putting work into the bathroom. Those are the two bigger areas where you get a lot more increase in equity for your investment. But very, very, very rarely do we see that, say the $30,000 put into a kitchen, very rarely do we see that the reimbursement is going to be the whole $30,000. The improvements generally are not a dollar for dollar improvement when an expert takes a look at it. And this does require an expert to look at it and figure it out. The flip side of this is when the community contributes to a separate property improvement. That is going to be a dollar for dollar reimbursement. And the reason for that is it doesn't even have to necessarily always be an improvement. If the community is benefiting a separate property parcel, remember the separatist doesn't have the right to improve his own or her own separate property estate at the expense of the community. So even when it is for maintenance of separate property, even when it is for improvement of separate property, the community is going to be entitled to a reimbursement for that investment in in one party's separate property real estate. That is the quick and dirty, and I don't know how to make it quicker or dirtier with regard to improvements, what is an improvement, what's not an improvement, and how to figure out who's supposed to get what. If you've made improvements to your house during marriage, or if you've made improvements to the other side's house or real property of any kind during marriage, you want to contact an attorney. Any competent family law attorney should be able to to discuss this in an intelligent way with you and let you know what your options are in terms of whether you have a buy-in or not, or whether you've waived it or not. And while we're talking about that, don't be signing any document that waives your right to reimbursement. Don't be signing any documents that just say, oh yeah, this new roof I'm putting on your separate property house is a complete and full gift and I'm happy to give it to you. Just stay silent. You'll find you're better off in the long run. I think that wraps that part up. I believe my next discussion is going to be with regard to commercial property, the different ways that we see commercial property valued. I hope this little series has been helpful regarding what you can get out of the family residence, and I hope you guys are prepped and moving forward with all of your lives.